Hi, my name is Collins, and today we'll be discussing private placement memorandum, due diligence, term sheet, and related regulations. Now, what is due diligence? Basically, that's the research and analysis of a company or organization done in preparation for a business transaction or like a corporate merger or purchase of securities. These are used for firms who want to raise their capital structure by way of the initial public offering, which is a company's first sale of common stock in the public market. So when certain companies sell their shares, underwriters form a group so they can share the risk and to sell a new security issue more efficiently. Now the main goal of this due diligence meeting is to list, gather, and authorize matters like the articles of incorporation, bylaws, patents, important contracts, and corporate minutes, so that everybody is on the same page. Now, investment bankers use this meeting as a final opportunity to ask management any questions about their financial integrity, their use of the proceeds, and any other issues relevant to their pending security sale. Now, these bankers attend the meeting to protect their reputations and lower the risk of lawsuits in case their investment doesn't go well down the road. Now, this meeting is good for investors so that way they can ensure that all issues about the firm are cleared up and that they aren't surprised by anything in the future. So basically, due diligence is just a good sense. It's the investor's duty to do their homework on a potential investment and is often essential to making prudent investment decisions. Private placement happens when there are also disadvantages of now, a term sheet is a non-binding agreement settling forth the basic terms and conditions under which an investment will be made. It also serves as a template to develop more detailed legal documents. It ensures that expensive legal charges involved in drawing up a binding agreement or contract are not incurred prematurely. So they generally cover the more important aspects of the deal without going into every single aspect covered by a binding contract. The point for businesses is to make sure that they figure out what terms really matter in the deal and think about those terms through thoroughly and express those terms in as much detail as necessary to make sure only one interpretation is made. And the structure and pace of the negotiation can have a significant impact on where the terms of the final agreement and on the relationship between the parties going forward. They can be used for setting the agenda and controlling the pace of negotiations, and they are used to set expectations for getting a final deal so everybody's on the same page. And they can include a timetable for conducting any necessary diligence, which can indicate what party will prepare the first draft of an agreement and the expectations for the time period for review and comments on the draft. It can include a timetable for signing a definitive agreement, including an outline of the lines of authority involved in the approval process. Related regulation is conforming to a rule such as a specification, policy, standard, or law. Describe the goals that corporations or public agencies aspire to achieve and their efforts to ensure that personnel are aware of and take steps to comply with relevant laws. The need for stronger regulation was highlighted by the Enron case, where a staff of executives used accounting loopholes, their shady special purpose entities, and poor financial reporting, and were able to hide billions of dollars in debt from failed deals and projects. Also, the Sarbanes-Oxley Act strengthened rules and regulations by enhancing standards for all U.S. public company boards, management, and public accounting firms. It also forces top management to certify accuracy of financial information. This is the same. This is part of the reason why Enron got in trouble as well. Their information clearly wasn't accurate, and they were able to get away with it until they were caught. In addition, penalties for fraudulent financial activity are much more severe than they were prior to the Enron case, And so the Sarbanes-Oxley Act increased the independence of outside auditors who review the accuracy of corporate financial statements and increased the oversight role of boards of directors. This definitely helps having an outside auditor, so then that way there's no cheating going on, and everybody will be on the same page and will know what is accurate. So, in conclusion, the term sheet, private placement memorandum, regulations, and due diligence all have some sort of relation to each other. In the PPM, a letter is usually sent out to the entrepreneur via an investment bank containing the term sheet for the bank to determine whether they can be seen as a client. And once that occurs, a due diligence checklist is given to the management team looking over the PPM. And also on that term sheet, it contains the rules and regulations that both sides agree to before signing their contract. If they were not to agree to those rules, then obviously the contract would be void.